So I'd like to welcome everyone to the February Bonar Institute webinar series. We're very excited that we have a fascinating presentation today by Scott Giordano. The topic of the presentation is what directors and officers need to know about cybersecurity mandates for artificial intelligence systems. I'd first like to make one quick note about the Bonar Institute. We are the Bonar Institute for Purposeful Leadership, and we focus on optimizing executive talent with purposeful leadership. We hope that you will visit our website today and learn about our offerings. In addition, you can link to our archive of webinars. And if you have a webinar topic that you would like to present to the boards in the C-suite, I'm inviting you to contact me about presenting that. So I will put my email in the chat feature, and at any time you can contact me by email. I would like to note that our president and founder, James Bonar, is in our webinar today. And I'm going to go ahead and start with a brief introduction of who Scott Giordano is. Now, Scott is a very distinguished attorney, professional, technology professional, and risk management professional with more than 25 years of experience as a lawyer and a consultant. It's hard to pack in all of the accomplishments Scott has had. And I like to brag about people's accomplishments because I celebrate people's accomplishments, but we would run out of time. But I'd like to note that Scott has some of the most prestigious certifications in the cybersecurity, technology, and privacy industries. He is an IAPP Fellow of Information Privacy. He is a Certified Information Security Systems Professional, CISSP. He is a Certified Cloud Security Professional, CCSP, and he most recently served as General Counsel of Spirion, which is a privacy technology firm. So, Scott, I'd actually like to continue bragging about all of your accomplishments. I do want to note I first met Scott when we were colleagues in the 1990s at a legal technology company called LexisNexis. And I always looked to Scott as a role model of hard work and what to study. And watching Scott in action caused me to try to improve what I learned, how I learn, and to be a better professional. So I'm truly delighted that we have Scott today. And Scott, I just want to remind everyone, we love to make this a conversational session. So you can always submit a comment in the chat feature. So like if it's a question you want to leave for the end or a comment, put it in the chat feature. But Scott welcomes questions that are spontaneous. So feel free to unmute and make a comment or a question. So Scott, it's to you now.
Wonderful. John, thank you for all the kind words. And yes, that check will be in the mail as soon as we wrap up today. So
I'm waiting on it, Scott.
Do want to welcome you all to my presentation today, what directors and officers need to know about the cybersecurity mandates for AI systems. And as John mentioned, yes, please feel free to bring up all your questions as I go through this. So really, why this presentation to begin with? One is that artificial intelligence has what I like to call a semantic extension to its attack surface. And semantic was the best word I could really come up with. It's the idea that there is something outside of the traditional CIA triad that we're all familiar with. It's something special, something different, something that's very based on meaning, hence the word semantic. Eventually, I'll come up with something better, but for now, that's what we've got. So as I mentioned, attack vectors we're all familiar with: unpatched servers, bad authentication, using OSs that are no longer supported, which shockingly is more common than I thought. Those are all the traditional CIA triad kind of problems that we've been working with for the last 25, 30 years. This is different. So you have things like model evasion, where you're tricking the model to do things it wasn't supposed to do. You're poisoning either the model itself or the underlying training data. So you're disturbing the integrity. And the poisoning can be very subtle. It doesn't have to be something that's obvious, which is actually a little more scary in that sense. You have what's called inversion, where you're tricking the model to cough up data that it wouldn't cough up otherwise. That's not just the model itself. It could be the database that takes all the information and turns it into numbers, which is called a vector database. Stealing vector data, you can then recreate it and get a fairly faithful representation of the underlying data. So just a couple examples of that. The folks at MITRE have identified, in my count, about 42 attacks that are unique just to AI. If you're familiar with MITRE's attack framework, they have a follow-on that's just for AI, and we'll talk about that as well. So why do you care personally? I presume everyone on here is either a director, an officer, or you're on the road to being one of those. So in the past 5-ish years or so, the threshold for Caremark liability has changed. We have this new-ish legal idea called the mission critical standard. And essentially what it says is that when a function is critical, mission critical to an organization, the standard for care is higher for directors and officers, or arguably the bar for suing them and holding them liable is lower. And so that's the mission critical standard. And interestingly, it also applies to cybersecurity. That seems to be in and of itself a core capability or a core competency that every organization has to have, regardless of their regular core competency, if you will, or their mission. So I thought that was fascinating. This standard now apparently applies to officers. There's a case called the McDonald's case that came out last year. I'll talk about that, but the net of it is it looks like officers are now in the crosshairs. Also, the SEC, as you probably all know, recently went after SolarWinds and its CISO. And that was interesting. I won't spend a lot of time on that unless someone asks, but essentially that's another avenue that's not necessarily Caremark related, but it's another avenue that the SEC can go after directors and officers. So if you leave with nothing else, AI has really amplified the ability of bad people. And we're going to see some examples. In fact, we'll see a lot of examples of that. Legal systems and standards in the US and EU are adapting slowly, and unfortunately, they need to do it, I think, a bit quicker. We're not there yet, but I'll share with you what we've got. As I mentioned earlier, we still have the mission critical standard that now, of course, is going to apply to artificial intelligence. So that's exacerbated, if you will, the mission critical standard. And yesterday was the time for getting ready, and I'll show why. So without further ado, AI as a force multiplier for bad people. I did not use generative AI to develop this presentation, with one exception. I asked ChatGPT some threats posed by AI, and shockingly, it did a great job. I think this is before they dumbed down ChatGPT, but it did a shockingly good job. So I mentioned earlier about adversarial attacks, making the system do something it wasn't meant to do. We're all familiar with deep fakes. I'll do a couple scenarios of deep fakes. Malware, taking the traditional malware we're all familiar with and making it more lethal. Social engineering, so phishing, essentially, and other things like that. And then what's called autonomous hacking, the idea of automating hacking. So not only do you have more lethal malware or more clever malware, you have it automated. So that's what ChatGPT returned to me, and I'm inclined to agree. So 4 principal areas for the InfoSec folks. So if you work in InfoSec, or you are tasked to oversee InfoSec for whatever reason, these are 4 distinct areas. And I wanted to break them out because I think they tend to be conflated into one big blob. And I think there are 4 distinct areas that we should talk about. One is traditional information security. So the CIA triad that we've talked about a lot. Also resilience. This concept of resilience was introduced by the GDPR. It's not just more access or more strength to your access protection. It's something entirely different. So that is now part. So I guess the triad is now, I don't know, a square, whatever it is, but that's really where we are right now with traditional information security. We've added resilience to that as a consequence. Privacy, not surprisingly, if personal data is scraped and then actors infer information about it, or perhaps they use it to find other personal information, then that's something that's dangerous for all of our well-being, because presumably they can use that data against us. Product and service development, this does not get talked about enough. So it's not enough to have your own cybersecurity. You have to make sure that everyone else in your supply chain does. This is something that I think all of us probably deal with on a daily basis. But what's interesting is that now you have the AI component of supply chain security. And so the idea that if you
And
have an
Scott,
AI system that
I
you're
would just
developing,
like
yep,
to make one quick
yep,
observation, because we have people from the Private Directors Association here.
yep,
One thing that's very important to remember
mm,
is a lot of the cybersecurity events
mhm,
actually start with a privately held company that is a
mm,
supplier to a publicly held company, and
mm,
that can
mm,
pull in a privately held company into securities litigation in a
mm,
derivative lawsuit. So
yeah.
there's a very interesting indirect connection with the
Yeah.
SEC regulations. I'll shut up for now, but I just wanted
No,
to make that note
it's a great
because a lot
comment.
of people don't realize that complex connection there.
Yes, and if there's anyone on the call or that's listening to this, to a recording of this, that's in the defense industrial base, you're already well versed with this idea of supply chain integrity. And so, again, AI is another challenge for supply chain integrity. And then finally, intellectual property. So we think about intellectual property as your copyrights, and there's a lot of litigation going on about copyrights vis-a-vis AI. I'll talk about those in a bit. But what's interesting also is what I call just confidential communications. The Sony Pictures hack, which I think is going to go down in history as one of the most embarrassing hacks, because all the email that was released by the bad guys, which was attributed to North Korea. And so all of the bad emails that came out of Sony Pictures, again, that was not pure intellectual property. It wasn't a contract. It wasn't a movie, although they did release some movies, but just the communications were so embarrassing, and it caused a lot of people to get fired. So it's a good example that protecting crown jewels is not enough. You also have to protect just day-to-day traffic. And with that, event-driven securities litigation can stem from any of these and probably multiple manifestations of these. I'm going to do a pause there. John, are there any questions or comments from the team?
So we don't have any in the chat feature, but we invite anyone to, if you have a comment or question, please unmute and ask. And
Okay,
you can do that at any time, by the way.
wonderful. So this is not a theoretical problem, at least not a purely theoretical problem. This study came out, I believe, last July, the Voice of SecOps report. Very, very impressive. And I'm just going to cite the headline for me anyway, is that 3/4 of the respondents have witnessed an increase in attacks over the past 12 months, with 85% attributing this to bad actors using generative AI. If that holds true, that attribution really is what they believe it is, that's astounding. And so, again, the idea that this is a theoretical problem somehow, or that this is something we'll deal with down the road, I mean, it looks like the problem not only is here, but was here and has been here for a while. Another issue is this idea of polymorphic software. So I alluded to that a little bit earlier. This concept was brought up to me last June when I read this article in CSO Online, where they talk about this idea of a chat GPT now being able to generate dynamic mutating versions of malicious code at each call. The idea is that every time it attacks something, if it's not successful, it simply changes and attacks again. So that is very disturbing. And I imagine folks that just do InfoSec daily, this is probably an issue, or if not, I suspect it will be. Another issue is this idea of unauthorized web scraping, and this is a legal gray area. This has been a battle that's been going on for years, quite frankly, on web scraping. You're probably familiar with Clearview AI. They were involved in web scraping, and in fact, the book that I have a photo of to the right, that talks a lot about Clearview AI and how they got all of their information. And it's a fascinating, some morbidly fascinating tale of how they were able to do all of this. And so they were fined in excess of about 75 million euro by the EU authorities over this. However, they didn't really get any fines over here in the US, just because our privacy laws just have not caught up with them. There have been lawsuits against OpenAI and Microsoft for intellectual property violations for scraping. And also those potentially the same lawsuit was filed against Google by the same law firm. And this has all happened last year. So this is a big issue, unresolved, and this is something that likely will wind up in the Supreme Court at some point. I know the Supreme Court's already ruled on scraping per se, but this is different because then this is incorporating things like copyright violations and whether that qualifies as fair use and all those fun things. So I think we're going to be at this point where we were 30 or so years ago with the Sony Betamax, I believe it was, case, one of the Supreme Court cases that okayed the use of videotaping TV shows. So voice deepfakes, I imagine by now you're well versed with hearing about all the stories of voice deepfakes. What I found interesting is I was at a Secure World conference probably about 3-4 months ago, and one of the folks from the Secret Service was there. He did a live voice deepfake where he spoke for 3 seconds into a microphone, and then the deepfake did the rest. The program did the rest, and it generated a convincing statement by him that he had not created, that it created itself. So voice deepfakes, yes, they're real. And you think about how we have voice authentication that's available now for banking and things like that, which seems like exactly the wrong application to be using a voice authentication for. But I know I've experienced it myself where they've offered me the benefit of voice authentication, which I promptly declined. And I think it was a good idea knowing what we know now. There's also this idea of visual deepfakes. And you've probably heard the story because it's fairly lurid that last February, a firm in Hong Kong was a person in the meeting, was the only human in the meeting. All the rest of the meeting participants were artificial intelligence generated. They were essentially visual deepfakes. And as a consequence, this person gave $25 million to the bad guys. And it was only after he called headquarters that he realized this was a scam. Probably should have called headquarters beforehand, before sending the money. But either way, this is a very, very hard lesson. And this is something that could have happened to any one of us, quite frankly. Another reason why I'm very much against these interview techniques, if you're interviewing for a job, where they'll ask you to make a video of yourself and send it in. Of course, when that database gets stolen, then all of those things can be used for all kinds of malfeasance. So not a good idea. This is the deep fake of President Zelensky after Russia invaded. So you can see that even 2 years ago, this was still very much a viable technology. It's not just something that's recent. Also, this idea of, and this is probably of all of my stories here, this is probably the most lurid one. So then this really happened, an AI experiment. This system, this was done, I guess, at an international conference, where this system called Megasin, which was designed to detect toxicity in chemical compounds, and then avoid them, was instead trained to do the opposite. And it was trained to go and create toxic agents that were based on the nerve agent called VX, which I think we're all familiar with here. And it generated 40,000 of these hypothetical biotoxic weapons in 6 hours, and many of which were more toxic than VX. So a great example of how this can be used in the real world by bad guys. Presumably they'd still need the equipment to generate this stuff, but the fact that this thing could create this out of thin air is just remarkable. And it's a great example of just the potential for harm for this. This idea of, and this is a great example of model compromise. So here are the researchers, and I put a link to the research. Researchers simply asked ChatGPT to repeat the word poem forever. And it started repeating it, but then after a while, it just started coughing up people's personal information that was in the database. And they were able to get a lot of data out of this trick. And in fact, I think the only reason that they stopped is because I guess it cost money to go and do this this exercise. They spent a couple $100 doing this, but they got quite a bit of data. Highly recommend you take a look at the article. It's excellent, and it really shows just this idea of exfiltrating and how easy it is. This is basically an inversion attack where you're tricking the model to cough up personal data, or any kind of data that you're interested in for that matter. This is the OWASP top 10 for LLM. This is 1.1. I know 2.0 is on its way. So these are the top 10 threats, if you will, to models. And it's great insofar as what it does. Not surprisingly, number one is prompt injection, the idea of putting in a prompt that is going to trick the model to do something that it shouldn't do, or a prompt that's very subtle, and you're essentially again tricking the model, for lack of a better word. I mentioned earlier about this idea that you have a semantic problem with AI, and I think this is a great example of that, where just because you have to expose this interface to the world if you want your model to be used, and then people can try their hand at tricking it to cough up information. It's, I think, one of the reasons that I presume you all use ChatGPT for. It's one of the reasons that I think a lot of people are complaining recently that it's terrible, because it just won't do anything. It's trying so hard not to do wrong things that it winds up not doing anything. And so it's quite interesting. I basically canceled my subscription to 4.0 because it's just not useful anymore. So I think that's in response to prompt injection and the fact that it's very hard to screen out bad stuff. There's all kinds of other threats to models. One thing that this does not give you, though, which I think was interesting, is it doesn't talk about threats to underlying databases like a vector database or to agents that the model is using. So I believe that the 2.0 version of this LLM top 10 will include those as well. I'm going to do a full stop, John, just to make sure there's no questions or comments or anything for that matter.
So far, we don't have anything in the chat feature.
Okay.
So, Stell or Laura, James, do you have any questions or comments? I actually, oh, Stell, please. I see you unmuted.
I'm just following along. I don't have a question at this time.
Well, wonderful. Well, Scott, I do have one thing I'd like to add
Sure.
in it. I think I talked to you about it yesterday, and that is the new report by IBM, and I hope I'm getting the right vendor they worked with. It's X Intelligence or X Report, can't remember exactly. But IBM had stated that they foresee that attacks on large language models will greatly increase when one of the LLM foundation models becomes the dominant technology.
Mm.
And when and I believe there's a market share threshold. I saw, I think 30%, and that when that threshold is reached, the threat actors in the world will focus on attacking AI. But
Sure.
right now, the focus is on using large
Mhm.
language models to attack. But in the future, as it matures, there will be more attacks on large language models. And then the other threat, of course, is the biggest threat right now is threat to the infrastructure that is used to support large language models. So I just think that's a very interesting subtlety that's going to evolve, which is going to require additional training and awareness for GRC programs and the CISO and the board, internal audit, et cetera.
What's interesting about your point, John, is you think about how Windows became the dominant OS in the world, and consequently how bad guys, if they tend to write malware, they're going to focus on that first. So I think that yeah, what that report stated was, validates that idea that they're going to go for the biggest target, which who knows what that will be. But yeah, it's a great example of how the bad guys will focus on whatever is going to give them the most bang for the buck.
Yes.
This is, those of you that are familiar with MITRE, which is a nonprofit that does consulting to the U.S. federal government for cybersecurity, among other things. They had a model called ATT&CK, which is a knowledge base, if you will, of all kinds of attack capabilities based upon when and where in the chain the attack took place. This is now Atlas. Atlas is essentially the attack plus AI. So you can see how the chain goes. You start with reconnaissance and then move over to resource development and initial access. And then you can have the different kinds of attacks. And any attacks that don't have a little ampersand are AI specific. So searching for victims' publicly available research materials, presumably because you want to find things that you may use to leverage an attack. Publishing a poisoned data set that winds up getting ingested, things like that. So these are all things that can happen, and I counted about 42 unique ones across this model. And again, starts on reconnaissance and goes all the way through all the steps until you reach the very end, which is the impact of your malfeasance, if you will. And so you can see that there's a lot of things that are centric just to AI. So again, another example, and I mentioned earlier about this idea of a semantic problem. This is really what I'm trying to capture, is this idea that there are things outside of the traditional access control and firewalls and all the fun stuff we've been doing forever, to really things that are much more esoteric and subtle and are going to require a consummate response. So at this point, you're probably wondering, Scott, how are legal systems addressing cybersecurity for AI, or how are they not? And that not is probably the better of the questions to ask. So let's talk about how things are done in the US. So right now, there's no AI-specific federal laws that address cybersecurity in the private sector. We do have a bill that is on deck right now, which is the Federal AI Risk Management Act of 2024, that would mandate the NIST AI risk management framework be used by federal agencies. That seems like a no-brainer. In fact, I'd be surprised if it won't happen through an executive order, but neither here nor there. That's something that's on the horizon. But again, that only affects federal agencies. They potentially could require contractors to the government to use that as well. And that's probably not a bad idea, but this is where we are right now. The FTC can punish unfair or deceptive acts. And one of the things that they could do is say that because you haven't taken appropriate steps in protecting your AI system or your AI supply chain, that's an unfair or deceptive act, and therefore we're going to fine you. So that's entirely possible, and that's a great avenue and a typical avenue for the FTC to use to punish poor cybersecurity. In particular, there's CIPP, which is the Child's Online Privacy Protection Act. And I bring this up because the FTC does tend to go after violations of child's privacy. They had a big fine they levied against Google and YouTube in 2019. And so if they're going to go after anyone on privacy violations, it's probably going to be CIPP first, because it's just so easy to do. At the state level, things are equally depressing, if you will. Again, no AI-specific state laws that address cybersecurity in the private sector. They all have, however, what we call, or at least I call, traditional cybersecurity laws. And this is a great example of one here. This is California's. And so it says, essentially, if you're a business, you've got personal data of a California resident, you shall implement and maintain reasonable security procedures. That language, implement and maintain reasonable security, or sometimes they'll say reasonable security measures or what have you. It's very, very common. In fact, just about every state has a law like this. And so as a consequence, they can simply go after you for poor AI cybersecurity just by using this statute alone. They don't necessarily need something to do that that's specific to AI. They're just going to ask you to look at the risks and then, as a consequence, apply controls accordingly. Now, California does have their privacy protection agency, which is their privacy police. It's the only state in the union at the moment that has a privacy police force, and it issues regulations, and it will be expanding them shortly. They've got 3 sets coming up: audit, risk assessment, and now this automated decision-making technology, which sounds very much like AI, but this even predates generational AI. It really goes back to regular AI, if you will, about automated decision making. So potentially you'll see regulations that govern that, including cybersecurity. There are some state-specific laws that govern AI. So you have the state FTC equivalents. You can argue that those are essentially just the same thing as the FTC, but it's a state level for unfair or deceptive acts. You do have state privacy laws like CCPA and CPRA. They talk about profiling and about automated decision making. So if any laws apply right now to AI, it's likely going to be those. Again, that's not really centric to cybersecurity, but that's literally what we have at the moment. In the EU, things are different. So EU AI Act, that was agreed to last December. Just this month, it was voted in and it made past a committee. And then the entire EU, I guess, Parliament will be voting on this in April. So in a month or so, and this will be law, and this will then go online the next 24-ish months. So right now, EU AI Act only applies to primarily high-risk systems. What qualifies as high risk, though, that's very interesting. I'll talk about that in a minute. In terms of to whom does it apply, it applies to really 2 sets of folks. If you're an entity within the EU and you're using this or you're providing it to others, you're subject to it. If you're an entity outside the EU and the input you have is intended to be used inside the EU, then you're subject to it as well. So potentially it has global reach. And if you're a provider, that is to say, if you're a software developer, you are going to have a a relatively higher regulatory burden vis-a-vis than say someone who's just a quote unquote user. This is the risk tiering system that they use in the EU AI Act. So 4 tiers. As you go up the pyramid, you will find you'll have more and more requirements. So at the very top is things that are just considered unacceptable. So social credit scoring, like goes on in China, that's essentially unacceptable. Biometric identification or mass biometric identification using AI, that's unacceptable. There are a couple exceptions. For example, in kidnapping cases or some other cases that they've carved out, but by and large, you cannot do that. Manipulating vulnerable populations, that's unacceptable. How does that look in reality? It's a good question. Again, it's going to be, I'm sure, resolved in litigation. Then you have really high risk, which is, as I said earlier, the bulk of the EU AI Act. So this covers, again, probably 80% of the act is really geared to high risk systems. So things that are considered high risk, critical infrastructure, especially digital infrastructure, are considered critical. Law enforcement, other government services, employment, recruitment, training, regular government services like administration of justice, those things are all considered high risk. And high risk means that there's all kinds of things that you have to do, which I'll talk about in just a minute. You also have limited risk. What's interesting to me about limited risk, which I didn't think was terribly limited, is that you have an AI application that makes things like deep fakes available or voice fakes available. That's considered a limited risk system, which I thought remarkable. Now, of course, you're supposed to put transparency on there that this thing was generated by AI, but yeah, good luck with that. So I think that limited risk is probably going to be a lot more risky than perhaps they think. And then you have minimal risk, which is anti-spam technology or anti-malware technology, and then video games. So that's risk tiering. John, I'm going to pause here. If there are any comments, thoughts, questions.
Well, I invite everyone to unmute or put a comment in the chat feature. I actually do have some comments. So what about state in the US, state unfair and deceptive trade practices acts? Would they be a potential source of liability in this context?
They'd be a definite avenue for liability in the sense that if you're an AI developer in the US or even a user, okay, you're using the technology, you're developing it, and persons from state X are adversely affected. Say that, for example, maybe your startup is in Massachusetts, you scrape data from folks in California, or you otherwise ingest their data and train on it, and then something horribly goes wrong. Perhaps that data is resold to employers, and it winds up that no one that uses that data, that applies for a job, gets a job, and you find out that it has a discriminatory effect. For example, that's an angle for liability under deceptive or unfair trade practices, or perhaps that they develop this database without really any consideration for security in and of itself, and bad guys break in and get all of that. I think we're probably on the call all familiar here with the break into the federal government that happened some years ago, Office of Personnel Management. I think this was probably back in 2007 or 8. And the bad guys got off with basically all the data about every single US employee going back, I think, 50 years or whatever it is. Also job applicants as well. So that kind of theft could be very, very powerful for bad guys, for intelligence agencies. And it's the kind of thing that in the private sector could definitely get punished under that Unfair or Deceptive Trade Practices Act.
And what about traditional, let's say, tort and contract liability theories that are not covered by statutes that codify case law or create exceptions to case law?
Absolutely. Again, when in doubt, you can always fall back to case law, to tort law. So in this case, just common law, an attack on negligence or an angle on negligence, saying that this company was negligent in handling something that was very important, and that the victim didn't give any permission to use in the first place. This is one of the things when you go use a negligence theory, is that you can argue quite truthfully that the bad guys went and grabbed all of your data. You did not give them permission in the first place. So it's hard for them to argue that they're not liable for the data that they took of yours and then not securing it and letting the bad guys come and grab it. So, and in fact, I imagine that class action or multi-district litigation would probably use that as one of the charges they would levy. It may not be at the top of the pile, but it'll be one of the charges that they'll include in their in their charging list, if you will.
It's definitely an interesting area to monitor. And I actually have been doing a lot of deep research through my bar association, access to legal research. And I need to tell you some things I discovered in a future phone call, some interesting developments.
Fabulous.
So anyone else have a comment or question?
Yeah, I do.
Yes.
And in the cybersecurity space, we all find it very frustrating that there isn't more, prescriptive requirements of compliance from various sorts. There's not just regulatory compliance, but pressures from third-party risk management and whatnot. And it's fragmented. It's inconsistently prescribed and enforced and whatnot. And we get some of the pressures to not do so. And so we kind of tolerate, what it is, but the real hard part isn't just getting our jobs done. The real hard part is then having leadership be able to sign off on some kind of, like, let's say, status that they want to express. And ultimately this is where it gets into legal, because they want to be able to say, we did what we're supposed to do, rather than we kind of met, the spirit of it, or our intentions are good, whatnot. So how well does this play in the legal side of things? I mean, on the practice side of things, it's a big problem, I would say. But once you get to, boards who want to make sure their organizations are both, let's say, secure, prepared for these changes and expectations coming from regulations in AI and whatnot, but also want to be able to say that they did enough to resist the litigation that might come to that might be put against them, whatnot. What's your, I'm asking you for kind of where your advocacy is on this. Like, does you or the legal world want to see more prescriptive requirements on protections that should be put in place for these new technological changes, whatnot, and privacy laws, whatnot? Or do you feel that having the outcomes or the intent to be adequate, and how would you advise a board to respond to those then?
I think the challenge with being overly prescriptive is that you don't want your prescriptions to become out of date. And that's always been my concern, is that if you do that, and a great example, the state of Oregon is very prescriptive on all the things that you have to do. And it's impressive in one respect, because they go through each leg of the CIA triad and tell you all the things that you would have to do at a minimum, which is great. You can, as another example, NYDFS Part 500, very descriptive. And they just updated it recently, because if you're just prescriptive, you have to update with regularity. So if you're going to be prescriptive, then you're going to have to really make sure that you're updating it. And let's face it, Congress still hasn't passed any federal cybersecurity legislation writ large. I mean, you have CIRCIA, which is breach reporting, but that doesn't really set a standard. So the net of it is that you have to choose your poison. If you have something that's prescriptive, then the government has to keep up with its prescriptions. If you don't, then you have to rely on what's generally accepted in the relevant technical community. That's our community. And right now, what's generally accepted? Well, we have ISO 27000 series. We have high trust. We have a couple other things that are generally accepted. So I think the correct answer for a board is to say, what are our peers doing? And are we benchmarking against the best of them? And I think that's a very hard argument, or a very hard approach not to argue with, because essentially you're looking at company X or practice X and saying, this represents the state of the art. We know if we have good reason to believe if we follow this, that if push comes to shove, we'll be okay in court. We'll show that we've at least met the standard and probably went above the standard.
I'd like to add a comment.
Sure.
So, Scott, I'm sure you remember when the EU AI Act first came out, I don't remember the year now, their original definition of artificial intelligence technologies was so broad, and it was done in good faith by smart people in good faith. But the definition actually would end up regulating traditional software applications that would not be considered AI technology based by the technical community, but it would come within the letter of the law. And that's why it was so significant that the EU AI Act aligned the definition of AI with OECD. So the OECD definition, I don't know if it's adopted word for word, but
I think so.
that is actually the danger. But what I am seeing in the context of cybersecurity, which I actually did a lot of research about what states are moving towards mandating using ISO as a standard for different market segments, very highly regulated industries, or the NIST framework. So I think we're moving in that direction. I think there are a lot of competing pressures. Also, in addition to the inability of government to keep up, I think there's some other forces that will prevent things from becoming too prescriptive. And in the U.S., I foresee it will be handled mostly by litigation, class actions, case law, and we'll develop case law. That's my impression, certainly.
Yeah, I think you're largely correct, John. And still, I don't know if that answers your question satisfactorily. It's a frustrating situation because you want to be able to tell the board something, and you want to be able to tell them something definitive. But it's very hard to tell them something definitive. There's those two approaches. Now, if we use ISO standards, that's great, but there's only a handful that you can actually audit against, at least officially. You can get a certification for 27001, et cetera. Otherwise, you're just going to have a regular auditor look at the ISO standard, audit against it, give you a report and say, here's where you succeeded, here's where you need to improve, and then use that as a working document. Ultimately, I think every single piece of advice you give a CISO and the CISO gives the board is going to be unique to that organization. And I think that's the challenge we're all facing, is that not only does not one size fit all, one size doesn't even fit most.
No, I absolutely believe your answer and understand it, but I don't like it. And you know, and my experience, you know, my professional experience has been heavily in banking, and I could tell you before NYDFS, what was that, just a few years ago, the rule, you know, whatever regulations came out, which touched almost everybody in the country because you just had to do some business in New York. They had the what was called the CAT, I can't remember what the acronym stood for. Where it was like a kind of a set of guidelines, which evolved into the full-on NYDFS rules. And I could tell you that the bank clients were ahead of everybody else because they had some standard to follow. At least it was a guideline now, and they were smart enough to know that someday this will become a rule.
Yep.
So there was a panel I moderated 2 years ago. It was called "Banks Did It First." And it was I had two CISO bank CISO friends, well, CIO and a CISO friends of mine, past clients, in effect, be on the panel with me just to talk about all the things that were kind of banks did this. Now it's no normal practice, but you know, 10 years ago, you know, or whatever it was, you know, the banks were already doing it, etc. So I don't know. I'm going to always make an argument for more prescriptive, and I absolutely get the burden of that, but boy, would you rather tell your insurance company, I did what you know, we all agreed on was the right practices. So because I had a problem, you can't, you know, deny my claim, just to give an example of something on the ground.
No, I think it's there's a lot of merit to what you're saying. And as far as giving bad news, lawyers are in the job of giving bad news. So so it's actually pretty common for me. All right, well, let's do this. Let's talk about the EU mandates. There's really 3 big mandates I want to share with you. I think the third one's going to be surprising, unless you spend a lot of time in the EU. You'll find the whole conformity assessment very interesting. So first up is a risk management system. Nothing should surprise you there that you have to have a risk management system in place. It's what we do here as well. So you have to do this, but not only do you have to have a risk management system in place, but you have to have a risk assessment done of the AI system before it goes into the market. So that's important. testing using defined metrics and probabilistic thresholds. And you might say, that's great, Scott. Where are these things? The answer is we don't have them yet. They are under development. Now, we do have the AI risk management framework. ISO, not surprisingly, has something on this as well. And in fact, the AI risk management framework has a crosswalk on one of its dependencies that will crosswalk you to the ISO standard. So that's great. We have that. We don't have these defined metrics yet. And again, those are on the way. More in that in a couple slides, though. So Article 15, this is the one I really wanted to share with all of you. This is essentially the kernel of the cybersecurity requirements for AI. And so it says that high-risk systems have to be resilient as possible. I mentioned earlier about resiliency and that you're going to see this material again. We're seeing it here. So resilient against errors, faults, and inconsistencies, which I thought was interesting. They didn't even talk about bad guys yet in this paragraph. They went all the way to errors, faults, inconsistencies. And then they said that you have to put in measures taken to regard this. So very interesting. Didn't mention confidentiality, integrity, availability, went right to resiliency. So that's a sea change. We're going to see more of that. Then Article 4, which is really, I think, the most important of all of this, they talk about how high-risk AI systems have to be resilient versus third parties. So there, again, there's resiliency. And then your controls have to be appropriate to the relevant circumstances and the risks. So back to your point, Stell, about how prescriptive does it have to be, here they're telling you, okay, you're going to have to go and do a risk assessment, presumably the one that was from Article 9, and then you're going to have to say, okay, what controls are going to be put in place? We saw the controls from MITRE, or at least all the vectors from MITRE that are being suggested there. So if you do that Venn diagram, that should give you a shopping list of controls that you have to go shop for. So that's a great example of how tying up those two things. And then here, what I thought, again, was very innovative is that it's not enough for your controls to prevent, detect, and respond to. Now you have to resolve and control for attacks. That's new. And again, these folks are pushing the edge of the envelope in terms of our discipline of cybersecurity, which I think is interesting. Whether it's good or bad, I think time will tell. But this is what they're asking us to do. And then they cite very specific bad things: model poisoning, data poisoning, adversarial attacks or model evasion, same idea. So these are things they're already calling out ahead of time. So I think that's very, very interesting. Also, you have this idea of no standards or guidelines at the moment for Article 15. ENISA, which is like CISA, but for the EU, they've suggested, use 2700 series, use 15408 for procurement, etc. So, which is great. We're basically saying use existing stuff for your bare metal, if you will, and then more will come along the way. 9001 was cited as well, and that's been around, I think, forever. So you can see that they're going back to basics. What they are saying, though, however, is that on the horizon, we've got at least two. We've got 27090 and 27563. This is cybersecurity for AI and AI use cases. So don't know where we are in the development cycle, but this is on the horizon. Finally, conformity assessments. And you've probably seen this CE symbol. I won't try to pronounce the French version of it, but essentially it's a conformity of the European Union. And essentially what it says is that your product, because it really was geared to products, is that it passes a certain set of safety tests. So, and if you make any kind of substantial change to your AI system, you're going to have to reperform this entire process. So that's a conformity assessment. It's essentially distinct from Article 9, Article 15, where you have to do your basics. This is in some ways a big picture assessment of the safety capabilities of your AI system. And so this is going to have to be done as well atop of everything else you've done. So there's a lot of work to be done on the horizon. So a couple things. There's 6 different areas where you have to have a conformity assessment, like technical documentation, record keeping, etc. And not surprisingly, cybersecurity is on that list. And so this laundry list here is coming from the folks at Future of Privacy Forum. So I decided to include that. Very, very good in giving you essentially the big picture of what a conformity assessment is going to look like. Okay. couple other things. Where are the standards? So standards for conforming assessments are on the way. The EU has asked for these to two EU standards organizations. They are coming supposedly by next April, so about 14 months away, across 10 areas, including risk management, governance, and cybersecurity. So those are the standards, hopefully, that we'll be able to use to audit and to develop risk assessments. Until then, we're on our own. So a couple more things about the AI Act I wanted to share with you in terms of when it goes into effect. So roughly speaking, 24 months. However, if you have a prohibited AI system, that's going to be subject to this in 6 months, which means it's got to go in 6 months. If you have a high risk system, depending on how you define that, that will be subject in 36 months, which sounds great, but the reality is that we're still waiting for standards, which won't be here for another 14 months. So you actually have a shorter window than perhaps you might think. And the penalties can be severe. If you're using a prohibited system, that's going to be up to 35 million euro or the greater of that, or 7% of your total global revenue. So that's pretty steep. And it can go down as low as 7.5 million. Presumably, that's for just regular errors in transparency and so forth. So they can be fairly severe, not surprisingly. And what we've seen with GDPR is that over time, I think that you found some jurisdictions were really good at just leveling fines all the time, big, small, and different, like Spain. You had some that would do a few fines periodically, like France, but they were pretty huge. And then somewhere in the middle, like Italy, which does a fair amount of fines, but they're not astronomical. So I think we're going to see that same kind of model here as well. And so why do all of you care about this? And that's really, I think, what's the whole point of this? So a couple things. One is that if you're a director or potentially an officer, if you're a director, there's two duties of care. You've got duty of care for the company to the world, and then duty of the directors to the company. And both have a standard of care. So if, say there's a breach, what happens after the breach? Well, you've got litigation, you've got your shareholder derivative lawsuits that I imagine you've all well versed with, and then you get your investigations. And so really, in terms of determining where the duty comes from, so you have your statutes, what we call sectoral statutes like HIPAA and GLBA, et cetera. We also have things that are very directed to public companies like Sarbanes-Oxley and the SEC cybersecurity regulations. Note that just because there are some publicly traded regulations here, privately held companies have plenty to worry about in terms of just sectoral statutes that apply to just about everyone, because typically they're based on institutions, whether they're private, public, nonprofit, et cetera. Also, this idea of what do you have to do? Well, you have to apply reasonable or appropriate care in developing security measures. And it's not you personally, you're an overseer, essentially. The officers of the company, though, do have to do this. And this is the standard that essentially, if you are in litigation, you're going to be charged with not having reasonable or appropriate measures, or at least not overseeing the implementation of those things. So the standard of duty of care, there's a couple different ways you can look at this. Tom Smedinghoff, who's an attorney from Chicago, very well versed in this kind of law in terms of cybersecurity litigation and just standards of care for e-commerce in general, does a really good job of just laying out essentially what every security program probably looks like, where you identify responsibility, identify your assets, et cetera, all the way down to addressing third-party issues. In many ways, you can look at what we're seeing here as everyone's cybersecurity program writ large, and then it's a question of just going very specific from there. Another way of looking at this, though, is through the lens of the board. So saying, for example, that here's all the to-dos the board should do. The board should have its own committee, or it should have its own responsibility for cybersecurity. Protocols should be put in place, and the board must discuss this on a regular basis. If there's a mechanism for reporting red flags up to the board, that way that they can then put their attention to it and direct the officers to go fix it. Having reports this is an interesting point that was made here in this case, that you have to have both favorable and unfavorable information. There's a report, you're going to get some things right. I've been through enough SOC 2 reports to know you're going to get a lot of things right. Occasionally, you're going to get things wrong that just are out of your control. And so both of those things need to go up to the board. And then finally, the board needs to use third parties because you can't rely just on your internal people to always get everything right. There's just, you need a disinterested third party to be able to do that. So in terms of implementing standards, there's a couple different ways you can implement the standards. I'm a big fan of the WISP, the Written Information Security Program. Think of that as essentially the connective tissue between the board and the officers, because officers are going to develop a WISP and they're going to implement the WISP, and then you can have reports on the program and go through metrics and specifics and all those fun things to be able to say, is the program actually successful? And so that's why I'm a big fan of this. Most states require it, in fact, and in fact, most major sectorial programs like HIPAA and high tech, et cetera, all require it as well. Couple things about getting information for the standard. There's all kinds of sources you can get for standards. They're everywhere. So you have frameworks. Those of you in the medical field familiar with HITRUST, I think we're all familiar with ISO 27001. You get guidelines published by the government. The one on the right that you see there, that was published by CISA and by the UK NCSC. ANISA is essentially the UK version, or I'm sorry, the EU version of CISA. So you have all kinds of publications. I mentioned earlier what's generally accepted in the relevant technical community, because that's what's going to be on trial. That's what's going to be on the stand whenever there's litigation. You're going to have an expert come on and say, yep, company X did everything that was generally accepted by the technical community. Then you'll have someone else on the other side say, no, everything they did was wrong, and here's why. That's essentially what happens in litigation. And they tend to rely on these kind of standards and guidelines to be able to show why they did what they said they did. In terms of enforcing it, you've probably heard way more about Caremark than you care to, but I want to at least repeat it, that there's two ways to hold directors liable under Caremark. One is they've made no good faith effort to ensure that there was oversight in place, controls in place, or they just consciously failed to monitor the controls they did have. And so that's the two angles essentially that a plaintiff's lawyer, tort lawyer will go after, or a securities lawyer will go after directors for, because directors allegedly didn't do their job. So we're all familiar with Caremark. What's interesting here about Caremark is that they, again, here in theory, you can render a director liable based upon their shortcomings in providing oversight. And this is based on the duty to loyalty that a director has to a company. That's something that I don't think gets emphasized enough, this duty of loyalty, and that's the theory, essentially, that was used here. It's something for directors and future directors really to keep an eye on. And so, so again, Caremark, this is something we've all heard about probably way too much, but that comes, I think, with the job. Also, McDonald's, this is a very interesting case from last year. Essentially, this was a shareholders' derivative lawsuit against the directors for sexual harassment that did not get resolved. Ultimately, the case lost on its merits because I guess they didn't make a demand directly on McDonald's board. But what was interesting about this is that the case held that stockholders can hold non-director corporate officers, like the CISO potentially, or in this case, I presume the HR director, liable for failures and oversight. That's fascinating. That brings in a lot of people under the ambit of liability that were not there arguably before. John, I'm going to stop here for a second. We don't have, I know, a lot of time left, and we're just about done with the presentation. Comments, questions, thoughts about anything that I've said thus far?
Well, I love all of this stuff. That's my background, all the Caremark stuff. I love getting deep into it, but a lot of people glaze over. Stel, Megan, any questions or comments? So I do. Oh, Stel, please.
I'm just want to compliment Scott on a nice comprehensive overview. So much stuff here that I don't touch on normally, so it's really a treat to get not just perspective, but some kind of good data. Thank you for having substance. I see too many things that are about like, here's the big picture. That's great. You're a board. You just need to know that it exists. No, sorry. You need to, let's gain some knowledge, at least know to be resourceful about it, because you're not going to remember all of this. But thank you. Thank you very much.
You're most welcome.
Level detail.
All right.
So I don't think we have any more questions or comments. Scott,
Okay.
Any more material you want to
We're
present?
just about done
Yes.
here. I want to share some things that I think you guys are going to find interesting. One is Yahoo. Again, I know we're all familiar with all Yahoo and all of the different breaches that Yahoo had because we kept getting spammed by all the accounts that were taken over. But what's interesting about this is that there was a derivative lawsuit settled for $29 million. That's not what was cool. What was cool is that this is the first time this was done based upon a data breach. So that's the first time, and it will not be the last. We're all familiar with Yahoo. It was bought by Verizon. Verizon eventually got a refund for a good chunk of the money they paid because of the underlying liability. So I thought that was fascinating. A good excuse to do a little more due diligence next time. Also, Facebook. This came out last year. Essentially, this Facebook derivative lawsuit litigation came about as a result of Facebook allegedly violating a consent order they had from back in 2012, which essentially concerned things that were being done back then that were bad vis-a-vis privacy. Later, Cambridge Analytica came along and did more bad things, and finally the FTC went back after them again. So this derivative lawsuit came about for that, and the judge allowed it to go forward. And you might not think that's such a big deal, but that is devastating because the fact that this lawsuit went forward and was not stopped means that likely this is going to go for a settlement, and it's going to be a hefty one. And this is again against Zuckerberg and the former and current board members. So a big, big, big deal. I can't underscore this enough. So mentioned earlier, mission critical. What else is mission critical? Well, as it turns out, cybersecurity. And so this is another case that came out, this fireman's retirement system, essentially said that the corporate harms presented by non-compliance with cybersecurity safeguards increasingly call upon directors to ensure that companies have appropriate oversight systems in place. That's a really long way of saying that if you're a director, you are now in the cybersecurity business, whether you want to or not. So again, this mission critical standard, the whole idea of mission critical came about when, and John, stop me if I'm wrong here, there was a creamery that had a listeria outbreak. Yeah, and of course, if you're a creamery, preventing diseases in your milk and your cream products is a top priority because you're in the creamery business. So that's considered to be mission critical. Boeing also had a similar one, not surprisingly, because airline safety or aircraft safety is core to their mission. And so if it's mission critical, the bar is lowered. How much lower? We don't know, but it's lowered enough that if you're watching this, you should be concerned.
Definitely.
So tying this whole thing together, Caremark and all the rest et al. So the market, the doctrine hasn't changed per se, but it's definitely, and this is someone else's view that I've subscribed to, by the way. It's newly invigorated, and the risks of Caremark liability are greater. The future liability is going to be centered on failure for mission critical tasks from the board perspective. And cybersecurity is one of those tasks. And so I personally believe that, yes, by being very proactive on cybersecurity, the kind of Caremark liability that we've seen earlier can be avoided. And we are just about done. So just a couple things, and we'll wrap up. As I mentioned earlier, AI, it's definitely a force multiplier for bad people and bad things. The legal systems in the EU are adapting, but it's painfully slow, or perhaps methodical, if you want to call it that. Board oversights have increased because of this idea of your core duties or mission critical duties, which now apparently are including cybersecurity in addition to everything else you do. And that apparently also includes officers. So if you are any kind of officer, not just the CISO, potentially you're exposed as well. And then finally, just a proactive, sustained effort on cybersecurity, especially vis-a-vis AI. I think that is going to be key, as is a much closer relationship between the board and the CISO. And this is something that I'm a big advocate for, as is John, and I imagine many of you are as well. So if any CISOs are on the call here, hats off to you. It's definitely, you have a tough job. And with that, just wanted to do a shameless plug for Director CISOs Alliance. Essentially, we do training for directors and CISOs and bring them together all as a team. And we address all the topics that we saw here today and things that you would expect to see that the plaintiff's bar would be very interested in bringing actions against. So that's it. And that's 2 of the team members there on the team. And that is it. And I think we did that in what, an hour and 10? No, hour and 7. Okay, that's pretty
7
good, John.
minutes. Beautifully done.
Scott,
Fascinating. Go
can I ask you
ahead.
a question, Scott? Yeah,
Sure.
Directors, get whatever, directors, insurance, et cetera.
Mhm.
How much does that protect them? Like, if now we say, well, look, you have this liability that you're obligated to oversee, make sure the cybersecurity program is adequate, et cetera, et cetera. Let's say it's very clear. And then there's a lawsuit that says you didn't do your duty. This data was exposed, these people were harmed, or whatever it was, and it's the board itself is sued. The board itself, because now these laws are making it clear, whatnot, but they have insurance.
Mhm.
And so, does it even matter?
Well, I mean, you think about what your insurance rates are going to be for directors and officers of insurance. So yes, and that insurance will cover that lawsuit. So if you're a director or now an officer, you get hit with a derivative lawsuit and you lose, yeah, that and potentially depending on the limits, yeah, that insurance is going to cover you. But how much higher now is that insurance going to be? And I mean, I'm sure you're painfully aware of how expensive cyber insurance is, assuming you can get it at all. I think that's going to be the challenge that directors and officers are going to have with their insurance now, is that either the rates are going to be skyrocketing or you're just going to get less coverage, which we do now in cyber insurance, which really should put the fear of God in you, quite frankly, when you're overseeing cybersecurity, because now it really has some real potential for harm for you, because maybe your limit on your director's officer's policy is not very high.
But wait a minute, that the harm is to the company who's paying for the insurance policy, not to the board member.
Well, yeah, you make a great point. And the short answer is I don't know exactly, how it's going to work, because you're right. The company is harmed, but the company took out the insurance policy, which is very typical, by the way. I mean, I think everyone has D&O insurance. So does that mean then that the directors have to indemnify the company? Arguably, yes. Because now they own it. Essentially, the company owns the rights. So the larger issue is, yeah, they're potentially subject to indemnity, and that's bad news for them as well.
Meaning that if now the company now has tripled their insurance rate because of neglect on let's say an individual board member, so now what they would sue that board member to cover the difference in insurance?
It's entirely possible. Again, I'm not a litigation expert, and John, I don't know if you have any insight on this, but the bad news is that all that you're inferring is true. I think that they potentially can go after the director for the difference.
So in a short, well, Stell, I just like to make a few comments. Number one, there's a wonderful podcast on this very issue I listened to last year. I will try to find that podcast. It's a very complicated explanation, but even the clawbacks can be covered. When there is when directors are held liable or sued for what was spent in insurance coverage, it's very, very complicated and arguably removes the incentives to cooperate with, to fulfill their fiduciary duties. But one thing I'd like to note, in my role at the Bonar Institute, the Bonar Institute focuses on purposeful leadership. And I developed with the Bonar Institute a training program for boards on artificial intelligence. It does not focus on cybersecurity. Cybersecurity would be one of the risks. It's a 4-part program. And we focus on more of a stakeholder analysis. Fiduciary duties are a component of it, not the focus. But purposeful leadership is about serving the broader stakeholder community with artificial intelligence and looking at the risks and the benefits of artificial intelligence, and being more than you have to be in terms of minimum standards. James, can you comment on the purposeful leadership aspect, because Stell is actually bringing up an important point. James and I have trained boards, and we have encountered situations where a board member has said, I'm protected by the business judgment rule. I don't have to pay attention to this. And the Bonar Institute is actually hired typically by the chair of a board who wants to upgrade board skills in preparation for an IPO or an M&A. So James, can you address the purposeful leadership aspect that I think Stell's question goes to?
Well, I can perhaps answer it this way, is that our focus is really on the leadership component of the individual board members and then their responsibilities as a leader and as a director. And what we say is for a board to be effective, all of the directors have to play their role fully as board members and assume the responsibilities there too. And that also goes for the C-suite. The point you're raising, all of you, about the liability issues of the board and who ultimately is responsible and can the company then sue them, is one I haven't thought of all that much. I do think of occasionally from the perspective of a fiduciary board versus an advisory board. And so we have a clause in our contracts with our advisory board members about insurance. But then my thoughts are, from the point of view of an advisory board, they really do not have any, or perhaps I'm wrong, any ultimate liability. So I'm wondering if that insurance is superfluous, but perhaps that's just a red herring to your question. And your initial question is about the fiduciary or the responsibility of the company versus the board, and can a company sue them? I really don't know what to say other than the fact that what we do with our clients is we stress the role, the importance, and the responsibilities of all the stakeholders, and chief of which, of course, are the board members and the C-suite and the company itself. I'm sorry if that's a bit vague, but that's the best I can do right now.
I mean, I'm surprised it hasn't happened. I mean, if you know, if this doesn't have to be in cybersecurity, it could be in, you know, then in financial matters.
I think it has happened already.
Okay.
I need to find the podcast. I'm going to have to do some digging.
Okay.
But this is an area I follow in minute detail. It's an esoteric issue, but it actually it has been discussed, and but we actually have run out of time. We are 15 minutes over, and I can talk about these issues for hours. I'm fascinated by them. Scott, I want to thank you for your hard work and presenting today.